Hey folks, Turbine Guy coming back at you. Now today I want to go over the order issued by Judge Moore in the case of Hennepin County plaintiff versus Paul Berquist, Benjamin Field Wilson, and Superior Dreams LLC. Right here we see order for mediation, court file number 27-CV-22-1089. The matter came on for hearing via Zoom on February 3rd, 2022. Plaintiff's motion for temporary injunction. Plaintiff was represented by two Hennepin County attorneys. Defendant Paul Berquist appeared and represented himself. Defendant Benjamin Field Wilson appeared, represented himself. There was no appearance on behalf of Defendant Superior Dreams LLC. The court heard argument from plaintiff and from individual defendants. Defendant Berquist told the court that he had provided an affidavit to plaintiff on February 2nd, but that he had not yet filed the affidavit with the court. The court also heard testimony from Sergeant Nicholas Folger of the Minnesota State Patrol. At the conclusion of the hearing, the court ordered Defendant Berquist to file his affidavit with the court by February 4th, 2022. The court stated that it would take the matter under advisement upon receipt of defendant's affidavit. Page 2. Based on the files, records, and proceedings herein, the court makes the following order. Number 1, by 4:30 p.m. on Friday, February 4, 2022, Defendant Paul Berquist shall file with the court the affidavit that he provided to the plaintiff, which Mr. Berquist did. By February 8, 2022, the parties shall jointly select a mediator for the case. If the parties are unable to agree upon a mediator, the court will appoint one. Plaintiff shall advise the court whether a mediator has been selected by 4:30 p.m. on February 8th, 2022, absent agreement of the parties to the contrary. The cost of the mediation will be equally divided among the four parties to this action. As soon as possible, but not later than February 18th, 2022, the parties shall engage in mediation and attempt to agree upon a way to quickly, safely, and legally move the yacht and trailer to a location where it can be legally stored. The parties shall negotiate in good faith to resolve the issues. All parties and all persons with authority to bind the parties shall be available to the mediator. The parties shall also have available at the mediation any insurance agents, licensing or permitting authorities, and any experts who may be necessary to achieve a full negotiated settlement of the issue of moving the yacht. If the mediation fails to produce an agreement as to how the yacht can be quickly, safely, and legally moved, each party shall submit to the court by February 22nd, 2022, now page 3, it's their proposal as to how to accomplish this objective. The party's proposal submitted to the court must include a cost estimate, a timeline for completion of the project, and must take into consideration the last mediation proposal by the opposing party and shall specifically address any perceived deficiencies in the opposing party's final mediation proposal. The court will take the motion for temporary injunction under advisement upon receipt of the party's submission hereunder. Plaintiff shall promptly provide defendants with a copy of this order. The attached memorandum is incorporated herein. Dated February 3rd, 2022, James A. Moore, Judge of District Court. Now we go to the last page, the memorandum of law, which really kind of explains everything. I like this. This case involves a very real danger to the public. A large yacht sits precariously, subject to a whole range of outside forces that may cause it to topple. It is sitting on public land where children and interested observers may play and gather. Moreover, it has fuel in it that is subject to spill. The court and parties must act quickly to resolve the issue and to move the yacht to a place where it can be safely stored. Getting it there, though, will require navigating a complex web of highway safety regulations, engineering issues, permitting issues, equipment availability, and cost. Against this backdrop, the court is asked to issue a blanket order abating the nuisance. Oh, were it that simple. Well, look at that. The judge has a sense of humor. Minnesota 65.04 requires that an order for temporary injunction be specific in terms and shall describe in reasonable detail the act or acts sought to be restrained. Okay, restrained. Here, plaintiff seeks a mandatory injunction, that is, in order to do something rather than to prohibit someone from doing something. In either case, the legal standard is the same, but the court is in no position to issue any detailed order as to how this apparent nuisance should be abated. There are simply too many unknown variables which prevent the court from giving accurate instructions for moving the yacht. The parties are in a better position to coordinate moving the yacht, and they must try to do so. If they cannot figure it out, the court is prepared to issue orders. In absence of a negotiated solution to the present problem, the process set forth in the foregoing order will give the court the information it needs to act. James A. Moore. Now let's get to the notes at the bottom of the pages, because this is where I really think Judge Moore put it together, filled in the blanks so that this order works. Note number 1. The court noted at the hearing that an LLC must be represented by an attorney. Mr. Wilson stated that he intended to hire an attorney to represent Superior Dreams within the next 30 days. 2. The order is being issued prior to receipt of Mr. Berquist's affidavit. Upon further reflection, the court believes that it is unlikely the affidavit would sufficiently resolve the factual issues raised by the pending motion, and that extensive discovery and further evidentiary hearing would be required. Under the circumstances, the court has decided to set a more expeditious course for this case. 3. Superior Dreams LLC must attend and participate in the mediation, but if it is not yet represented by counsel at the time of mediation, it may participate in the mediation through corporate officers or officials who have the power to bind the LLC. Although a full and final resolution of all claims in the lawsuit is desirable, the focus of the mediation shall be on the issue of moving the yacht. Period. Other issues such as claims for damages can be reserved for consideration by the court if necessary. Defendants may submit a joint proposal or may submit individual proposals. That's number 5. So, what is Turbine Guy's take on this order and what's going on? Well, I think Judge Moore took an overall viewpoint, listened to what Mr. Berquist said at the hearing, and decided that, you know what? The prosecution kind of fell on its face. It didn't provide me with the evidence I needed, barely provided me with anything other than accusations and innuendo. And we've got to find a framework around which this problem can be solved instead of pointing fingers at each other. Not only that, he expects all the parties to actually work together to solve this problem instead of be at loggerheads bashing on each other all the time. And I think there's a phrase in here that's really telling, that kind of a little bit of a slap on the wrist to the prosecution here, when he says, here, plaintiffs seek a mandatory injunction, that is an order to do something, rather than to prohibit something from doing something. He pointed out something here. Restraining orders are to stop people, to prohibit things. They aren't to really force people into action. And although he says the legal statutes, legal analysis is the same, he's also pointing out that what are you doing when we're all sitting here in agreement that this boat needs to get moved, hammering down his throat, trying to get an injunction, which really means nothing. Well, you know, the reason to me that they went for this injunction was it was a first step in taking control of this boat. Well, I think the judge didn't fall for that. I think the judge wants to solve the problem. I think Judge Moore is on top of this. And I personally think that Judge Moore wrote a tremendous order, given the limited information he had, in order to get this situation resolved in an expedited manner. And I'll tell you what, I think the Turbine Guy says, Judge Moore, great job. Turbine Guy, signing off.